Jamell Demons, present as defendant. His counsel, I see two of his counsel, or three.
Mr. Howard is on his way up.
All right. Are we able to proceed without Mr. Howard?
Yes.
All right, and we have assistant state attorneys as well. So the jury had a question. The question reads, where can we find the call logs of the 9807 number? Then the second says, can we hear Mr. Kelly testimony, Trayvon Glass, Cortlen, Sutherland? When I look through my notes, am I missing something on Courtney Sutherland?
Your Honor, there were 27 witnesses that testified, no one by that name. I don't know if they're trying to refer to the statement of Cortlen Henry, if they mean one of the other witnesses. I don't know if you need to read them. The list of the witnesses that testified, ask who they mean.
Any suggestions from the defense?
Maybe ask what they think this Courtney Sutherland testified to, and based on the basis of the testimony, we could probably figure out which witness it was.
I would suggest he respond back that there is no witness by the name of Courtney Sutherland.
So my thought would be, that's what I would do. I agree with you, counsel. I would just say, please clarify regarding regarding Courtney Sutherland. We have no witness by that name. Is that all right with the state?
Yes, Your Honor.
Defense?
Yes.
And what about the call logs?
So that is on States 63.
States
and
53 or 63?
63, and then it's within subfolders therein. So there's multiple call logs for the 9807.
Right. So state 63, Madam Court Reporter, regarding Mr. Kelly, you indicated that it would take you how long to get Mr. Kelly's testimony ready?
Probably not till tomorrow.
Probably not till tomorrow. And on trivia and glass, you're ready to go on that, correct? Is that right?
Yes, Judge. Besides, I just need to go through it.
Yeah, you need 15 minutes or so.
Yeah.
All right, so just indicate for the record that the court reporter is advising you to take about 15 minutes or so to be ready on Mr. Glass's testimony. Mr. Kelly should have by tomorrow, and regarding Ms. Sutherland, we need clarification. So I'm just going to write that back. Let you know what it is.
Point. The computer in the back might not have Excel on it to be able to open the call logs for the 9807 phone number. So we could provide a printed copy of those.
Counsel, is there any objection to that?
we have a moment on that?
Sure.
Judge? And I think there's another question.
Step outside, please. Step outside, please.
Is on the question, where can we find the call logs of the 9807 number I indicated? Please refer to State's Exhibit number 63. And below that it says, can we hear Mr. Kelly testimony of Trevion Glass, Courtney Sullivan? I said, please clarify, Courtney Sullivan did not testify. Trevion Glass's testimony can be read back today. Michael Kelly testimony needs to be prepared for read back probably tomorrow. Any objections?
No.
In terms of the printed version, counsel?
We're not agreeing to print it out. Whatever's in evidence is evidence. So if that's the computer chip or whatever, that's what I should look at.
Can I see counsel sidebar for a second?
Yes, sir.
Gary,
Yes, sir.
can you give this to the jury to know the whole of this note? Do not destroy the notes, though we need to report file. The record reflects the presence of the defendant, his counsel, his state attorneys, the jury's adjournment. We have a new jury inquiry question. It says clarification. Courtney Sullivan should have been Cortlen Henry. We have decided we do not need to hear his statement from the hospital. Trevion Glass, we would like to have his testimony read back. Michael Kelly, we would like to have his testimony read back when available. So my thought is just to bring him in, and we'll have him read back Trevion Glass' testimony now. I think court indications ready on that. Is that right now?
Your Honor, I'd like to take a few positions with respect to the questions. Would permit. With respect to the reading back of the testimony, our position is that testimony is comprised not only of its substance, but the manner in which it's delivered. When we are in a fortunate situation such as this, where the entire testimony is captured on video camera, we think it would be more appropriate for the jury to either be told to rely upon their recollection, because even though their recollection would be incomplete, it would be comprehensive. They'll be recalling not only what was said, but the manner in which the person testified. A gentleman like Trevion Glass in particular, who was hiding behind the monitor for half of his testimony and then hiding deliberately behind his dreadlocks for the rest of his testimony, I think his testimony is going to look a whole lot better on paper than it did when it was delivered. The best evidence of his testimony was captured on videotape, and the jury would be able to see it. And so we would suggest that since we're in a situation whereby the testimony has been captured on video, that the best practice in this instance would be that any testimony that is asked back for not be read back, because it would be devoid of its context, but be shown. And with respect to Mr. Kelly, Officer Kelly, whose testimony won't be available until tomorrow, it would also expedite matters because I'm sure it would be a lot quicker to obtain video footage than it would be to have it typed up. My other point would be this. The request for the testimony of Mr. Glass and Kelly both came in the same question. And subsequent to that, we received a note that indicates that there may be factions that are beginning to calcify. We can only speculate as to what the jury is thinking and saying. But I think it's unequivocal that the substance of Mr. Glass's testimony favored the state. It is also unequivocal that Mr. Kelly made some concessions that essentially his analysis had defects and he really couldn't draw the conclusions that he was attempting to draw. So one can surmise that maybe that might be more favorable to the defense. If we have a jury that's now divided into factions and one side is sending for information that might support their argument, another side is sending for information that might support their argument, then I think it would be unfair if we allow one side of that faction to get their ammunition and wait another 24 hours before the other side is able to meet that argument with whatever they're trying to fashion or whatever that testimony they're using as a component of their position. So we think it would be prejudicial because we got both requests in the same questionnaire or same question asking for the testimony of both people. And until both is available, first of all, we'd like it to be shown back as opposed to be read back. And secondly, we think that it should be done at the same time so that both sides, assuming they're for different sides, are equipped with the ammunition they need when they go back and the deliberations continue. But we think it would be extremely prejudicial if Mr. Glass's testimony were to be read today and we tell them, wait until tomorrow before we get your papers.
Thank you, David Spears.
Your Honor, it's entirely speculative. The rules would conform with a readback occurring in the state. It suggests that Your Honor should stick to the rules of criminal procedure on this case.
So objecting to having some type of seeing what crime and whatever the more crime video is and have that played back to you.
Yes, Your Honor.
Anything else, counsel?
Yeah, well, once we can ascertain that it's complete, then clearly it's the best evidence. There might be rules which do not contemplate the existence of video, but now that we know we have it, the court as the gatekeeper knows that it will not be an inaccurate reflection of what has occurred. As a matter of fact, it will be the best evidence of what occurred. And therefore, to use a procedural deficiency as a basis for objection, I think is an attempt to obfuscate what would be the best evidence and the truth. And I don't think the state took a position with respect to whether or not it should be read at the same time, but we would maintain that it would be prejudicial to Mr. Demons. And I know we're reading tea leaves, but because we don't know what's going on, it's all the more important that we give the jury what they asked for at the same time that they asked for it and not split it up.
Thank you. Well, counsel, respectfully, the court reporter is the person who keeps a record of the proceedings. So if they want to read back, that's what we're going to do. We're going to have to read back. I understand the case was live streamed, but that's not in evidence. The court reporter can read it back. That's what the rules provide for. That's what we'll do. Regarding Mr. Glass and Mr. Kelly, Mr. Glass is read back. My understanding his testimony is relatively short. It didn't take the court reporter too long to do that. She's going to read that back now. She's working on Mr. Kelly, and when that's available, she'll read Mr. Kelly as well. You're good. It's over.
Thank you, sir.
You bring the jury?
Yes, sir.
in the jury room, you wanted to supplement your positions there?
Yes, please. In lieu of them watching the testimony, which we maintain is the best alternative, to allay some of the concerns we have with respect to prejudice, we would ask that an instruction be given to the jury reminding and admonishing them that a readback cannot reflect the matters of demeanor, tone, or voice in which the testimony was given. So we ask that the jury be reminded that a readback is not a complete accounting of the testimony because it doesn't account for manner, tone, voice, and the things which they may have observed. So we ask that that instruction be given prior to them getting the readback or after.
Stay with you.
Your Honor, there is a standard jury instruction 4.4 that covers this. That would be the state's position that that's what Your Honor is reading.
Let me take a peek.
Thank you. That's what I typically would do, counsel, to read back the standard jury instruction.
I do notice that that the headings of each one of these speaks to readback / playback. So I do believe the rules do contemplate a playback as opposed to a readback. Just to correct the record, because my understanding from the state was that a playback was not called for, but this proposed rule does actually mention playback.
Thank you.
Your Honor, also, this Rule 4.4 does not contemplate the issues that are concerning, particularly with respect to Mr. Glass hiding behind the monitor and behind his hair. We think that it's important that the jury be reminded that tone, manner, and comportment during testimony are also important in their assessment of credit. So we ask that not just the standard.
Thank you.
Thank you.
Now, State, anything additional? Two things, counsel. Number one, my understanding of the readback, playback issue has to do with evidence. That's something that's in evidence that's going to be played back to the jury, not trying to find out something that was live stream, not in evidence to play back to the jury. I think there's a difference. That's the first thing. Second thing, regarding the witness, my recollection was you said he was hiding behind it. My understanding is you asked him, or somebody asked him a question about it, and he said he was blind in one eye. I thought that was the issue. He was blind in his left eye. But regardless, I'm sure it's in the transcript. But your objection, I'm just going to read this thing. All right? Bring the jury in.
Thank you.
Jury answering. Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the defendant, his counsel, the assistant attorney. I have a jury inquiry form. It says request of view evidence. It states clarification. Courtney Sutherland should have been Cortlen Henry. We have decided we do not need to hear this statement from the hospital. Then it goes on to Trayvon Glass. We would like to have his testimony read back. Michael Kelly, we would like to have his testimony read back when available. So what I've done, ladies and gentlemen, I've talked to the court reporter, and she is able to read back the testimony of Mr. Trayvon Glass at this time. I discussed this with the attorneys, and the court reporter is going to read that back now. As far as Michael Kelly, she's working on getting that done, and as soon as it's ready, we will have it read back to you, his testimony. So, Madam Court Reporter, could you read back the testimony of Mr. Trayvon Glass, please? Sure. You need to take the microphone down.
The court, call your next witness, please. Ms. Smith, Trayvon Glass. The court, are you ready, Mr. Glass? The witness, yes, sir. The court, welcome. This is our witness stand over here. Once you come to the witness stand, what I'd like you to do is remain standing and raise your right hand to be sworn. The clerk, do you solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth? The witness, I do. The clerk, state your full legal name for the record. The witness, Trayvon Glass. The clerk, please spell your first and last name for the court reporter. The witness, Trayvon Glass. The court, please have a seat. Mr. Glass, that microphone in front of you, only adjust up or down. It doesn't move back and forth. The witness, all right. The court, so if you could scoot up close to the microphone. Ready to proceed, sir? Counsel, you may. Ms. Smith, thank you, Your Honor. Direct examination by Ms. Smith. Question. Good morning, Mr. Glass. Answer. Good morning. Question. I know that you are quite soft-spoken, so I'm going to need you to speak up a little louder. Okay? And remember, you have to make oral responses. Okay? Answer. Yes. Question. How old are you? Answer. I'm 23. Question, and where are you currently living? What city? Answer, Vero Beach. Question, and have you lived there all your life? Answer, majority of it. Question, okay, you completed high school, or what was the last grade you completed? Answer, 11th. Question, all right, you're not married, correct? Answer, excuse me? Question, you're not married? Answer, no. Question. So I'm going to talk about some prior stuff before we get into why you're here today. Have you previously been convicted of a felony? Yes or no? Answer, yeah. And how many times? Answer. To my best knowledge, once. Question. If I were to show you something, would that refresh your recollection? Answer, yeah. Question. The prior judgment? Ms. Smith, Your Honor, permission to approach the witness? The court. First, show counsel first, please. Ms. Smith, yes. Question. I'm going to ask you to just look at the document. Don't say anything, okay? Have you had an opportunity to review the document? You have to answer. Answer yes. Question. All right. Is your memory refreshed as to how many convictions you have? Answer 2. Or is that 1? I don't know shit. I see 2 charges. Question. All right. Now you currently have some pending charges in Indian River County, correct? Answer, yeah. And those are 2 charges? Answer, yeah. Question. Misdemeanor resisting without violence? Answer, yeah. Question. And an obstruction of service or execution of a search warrant? Answer, yeah. Question. Are those misdemeanors or felonies? Answer, I'm not sure. Question, okay, do you know what the penalty you are facing on those charges? Answer, no. Question, have you been offered probation in that case? Answer, yeah. And have you been made any promises in exchange for your testimony here today? Answer, no. Question, all right. So let's go back to October 26, 2018. What were you doing like for work? Answer, I wasn't working at all. Question, were you involved in the music business at all? Answer, kind of, sort of. Question, and how so? Answer, making beats. Question, all right, and when you were making beats, were you working with a specific group or music group or people? Answer, one person to be particular, but yeah, it was supposed to be in a group. Question, all right, let's start by saying this. What group was it? Answer, in YNW. Question, all right, and when you said one person specifically, who was that person? Answer, Juvy. Question, and can you tell the members of the jury Juvy's real name? Answer, Christopher Thomas. Question, and how long had you known Christopher Thomas, who you refer to as Juvy? Answer, over a decade. Question, and this is back in October. And did you know somebody by the name of Anthony Williams who went by Sack Chaser? Answer, yeah. Question, and how long have you known Sack Chaser? Answer, a couple of years. Ms. Smith, permission to approach the witness with State 73. The court is in evidence. Ms. Smith, yes. The court, yes, you may proceed. By Ms. Smith. Question, Travion, I'm going to ask you to take a look at State's photograph number 4 in State 73. Do you recognize that person in State's photograph with the label marking 18-3118? Answer, I do. Question, and who is that? Answer, Anthony Williams. Question, so back on October 26, 2018, do you recall being at the New Era studio? Answer, yeah. Question, who were you with? Who were you there with? Answer, a few other people. Question, okay, was Juvy and Sack there? Answer, correct. Question, all right, and do you recall around what time you guys got to the studio? Answer, I'm not sure when we arrived. Question, was it light or dark outside? Answer, I believe it was dark, I'm not sure. Question, all right, and what was the intention going to the studio? Answer, I believe we were supposed to have a 12-hour session. Question, all right, and that's a 12-hour recording session, right? Answer, yeah. Question, and who was the artist that was recording that night? Answer, it was everybody. Everybody was an artist in that room. Question, all right, did you guys end up staying for 12 hours? Answer, nah. Question, okay, what changed and why didn't you end up staying? Answer, to the best of my knowledge, people were sleeping, so we ended up going home because you don't sleep in the studio. Question, all right, and part of that is because studio time is paid for. Answer, paid for. Question, okay, you just said it was paid for. What was paid for? Answer, studio time. Question, so you guys had prepaid for 12 hours? Answer, correct. Question, I'll move on. How long? Well, you said that people were sleeping. Who was sleeping? Answer, everybody but me, Anthony, and Christopher. Question, was someone upset that people were sleeping? Answer, I guess you could say that. Question, and who was that person? Answer, Sack. Question, and how did Sack respond? How did Sack respond to people sleeping? Answer, he woke them up and let them know it's time to go. And how did he do that? Answer, yeah, he went and woke them up, shook them up. Question, okay, so at some point you just mentioned that guys were getting ready to leave the studio. Answer, yeah. Ms. Smith, publishing State 72, publishing image number 1 in State 72. Question, Mr. Glass, can you see that photo on the screen in front of you? Answer, yes. Question, okay, and who is that person? Answer, to the best of my knowledge, Melly. Question, okay, and the person I'm referring to, what is he wearing? Answer, a jacket. Question, all right, do you recognize the person on the other side of the photograph wearing what appears to be a black shirt? Answer, kinda, sorta. Question, if you do? Answer, no, I don't. Question, publishing image number 2. Do you recognize individuals in that photograph? Answer, 2 of 3 of them, yeah. Question, okay, so what you can do is identify them by clothing that they are wearing. Answer, Juvy, black jacket to the left, sack in the middle, jean jacket, Tay, black jacket. Question, and sack, is he standing or sitting? Answer, sitting. Question, and Tay, is he standing or sitting? Answer, sitting. Question, and you said Cortlen was wearing a black jacket. Is he standing or sitting? Answer, who? Question, how did you refer to him? My apologies. Answer, Tay. Question, no. Answer, Juvy. Question, the person wearing the black jacket, who did you identify that as? Answer, Juvy is wearing a black jacket. Also, it's Tay wearing a black jacket. Question, the person wearing the black jacket who is standing up, do you recognize that individual? Answer, that's Chris. Question, okay, do you recognize the people in photograph image 3? Answer, same one you just showed, same person. Question, and who is that person? Answer, Melly. Question, the 3 images that were just shown from State 72, do you recall when those photographs were taken? Answer, same night. Question, would that be, what date would that be? Answer, 10/26. Question, of 2018? Answer, yeah. Question, what location were those photographs taken in? Answer, New Era Promotions at the studio. Question, was that the studio we just discussed that you guys were hanging out at? Answer, yeah. Ms. Smith, I'm now publishing Stage 7, publishing 10/26/2018, beginning at timestamp 2/17/42. Question, Mr. Glass, do you recognize the 2 individuals on the screen paused at 2/17/47? Answer, do I recognize the back of their head? Answer, yes. Do you recognize them? Answer, I just see the back of heads. Question, okay, I'm going to continue to play. Do you recognize anyone at timestamp 2/17/52? Answer, still the back of the heads. Question, do you see an individual standing next to a red vehicle? Answer, yes, that's Kobe. Question, you just said that's who? Answer, Kobe. Question, and what is Kobe's real name? Answer, that's what I know him by, Kobe. Question, all right, would anything refresh your recollection as to his legal name? Answer, I don't know. Question, if I were to show you your prior statement, would that refresh your recollection? Answer, it could. Ms. Smith, permission to approach the witness? The court, you may. Question, Mr. Glass, if you could take a moment and look at this page, read it to yourself, do not read aloud, and look up when you're done. Has your memory been refreshed as to the legal name of Kobe? Answer, yeah. Question, what is Kobe's legal name? Answer, Jacoby Mills. The reporter, I'm sorry, the witness, Jacoby. By Ms. Smith. Question, all right, if you can repeat the last name for the court reporter. Answer, Mills. Question, I'm going to continue to publish Stage 7. There is a second individual at the red Mitsubishi vehicle. Do you recognize that second individual? Answer, not really, no. Question, okay, how about the individual that is standing at the gray Jeep? Answer, that's Zach. Question, I'm going to continue to publish. I'm pausing at timestamp 2:18:21. Do you see that individual who's walking away from the Mitsubishi Jeep? Answer, I see him. Yeah. Question, do you recognize him? Answer, that's AD. Question, I'm going to ask you for AD's legal name. Answer, I know his last name is Davis. Question, okay. Would looking at your statement refresh your recollection as to his legal name? Answer, I guess so. I don't know. Ms. Smith, Your Honor, permission to approach the court. Is that the same statement? Ms. Smith, yes, Judge. Approaching the witness. Question by Ms. Smith. Mr. Glass, same procedure. If you could take a look at that and look up. Answer, unintelligible. Question, no, without speaking. Has your memory been refreshed as to AD's legal name? Answer, yes. Question, okay, what is AD's legal name? Answer, Adrian Davis. Question, continue to publish state 7. Mr. Glass, let me know if you need to rewind the video. Did you have a chance to look at the face of the individual wearing what appears to be a white shirt and blue shorts? Answer, that's me. Question, continuing to publish. I'm pausing the video on 2:18:41. Do you see that individual carrying something across his shoulder, wearing what appears to be a blue jacket? Answer, say that again. Question, do you see the person on the video? Answer, I see the back of his head. Question, do you see the back of the head of the person wearing the jean jacket? Correct. Answer, correct. Question, do you see the jacket in state 72, image number 3, the front of the jacket? Answer, yeah. Question, do you see that jacket in state's image 1 of state 72? Answer, I see the same thing y'all see. Question, we spoke about this, Mr. Glass. Answer, I said that. The court, excuse me. Counsel, you ask questions, all right? By Ms. Smith, question. I'm asking questions, Mr. Glass, and just asking you to respond if you have knowledge. Is this the jacket that was in image number 1 and image number 3, the jacket that Melly was wearing on October 26th of 2018? Answer, to the best of my knowledge. Question, to the best of your knowledge, yes or no? Answer, yes. Ms. Smith, publishing state 7. Question, I'm back to state 7, timestamp 2:18:41. The individual that's on screen wearing the jacket, it appears something across his back. Who is that individual? Mr. Glass, can you respond? Answer, I see the same person as last time. Question, okay, and can you tell us who that same person is? Answer, Melly. Ms. Smith, continuing to publish. The witness asking questions I don't know the answers to. By Ms. Smith, question. Mr. Glass, you can't speak when there's not a question. Mr. Glass, do you see that individual carrying something in their left hand? I'm asking you if you see them, just if you see them. Answer, yes. Question, do you recognize that person? Answer, of course. Question, and who is that person? Answer, Christopher Thomas. Question, Mr. Glass, can you identify for the record? I know there's a video, but can you identify which vehicle you got into? Answer, the red Mitsubishi. Question, and can you tell us who was in the car with you? Answer, Kobe, Tay, and AD. Question, so AD, Tay, and Kobe. Answer, Is that a yes? Answer, yes. Question, so that is a total of 4 people. Answer, correct. And in the vehicle to the left of the screen, the Jeep, who entered that vehicle to your knowledge? Answer, everybody else that was there. Sack, Melly, Juvy, and Cortlen. Answer, okay. I'm sorry, question, okay, and by my count, is that also 4 people? Answer, correct. Question, and when those continuing to publish at 2:19:36, I'm going to stop at 2:19:46. At the time you left the scene in that red Mitsubishi, where were you headed? Answer, supposed to be home. Question, who's home? Answer, I guess Melly's house. Question, and was everybody in that red car headed to Melly's house? Answer, to the best of my knowledge. Question, and what about the Jeep? Where was your understanding that the Jeep was headed, the gray Jeep? Answer, same spot. Question, so both cars left the studio with the intention of heading to what you identified as Melly's house? Answer, correct. Question, can you tell us, I guess, what was the mood or the vibe of the studio while you guys were there? Answer, it was years ago. I can't tell you nothing right now. Question, okay, if you don't recall, that's fine. Was there any physical confrontation that you observed at the studio? Answer, just like a regular day at the studio, smoking and drinking. And you just mentioned smoking. Where are you smoking? Specifically you. Answer, weed. Question, all right. And now the vehicles. We saw that the gray vehicle on the video pulled off first. Can you tell us where you guys, the route you guys took to the best of your knowledge? I can't tell you because I don't know. Do you recall getting on a highway at all? Answer, I recall being in the car while it was driving. I don't know where. I don't know. I don't. Question, were you awake the entire time you were in that vehicle? Answer, I wasn't. Question, okay, do you know at what point you fell asleep? Answer, I don't. Question, all right. And when you left the studio, you were awake. Is that a fair statement? Answer, I was. Question, and at what point do you recall waking up, or what time do you recall the next thing you saw? Answer, once it came to a stop. Question, all right. And where did you come to a stop? Answer, at the house gate. Question, at the house gate for Melly's house? Answer, yeah. Question, when you got to the house gate at Melly's house, who was inside your vehicle, the red Mitsubishi? Answer, same people you've seen get in the car. Question, by your testimony, Kobe, AD, Tay, and yourself? Answer, yes. Question, okay, so still 4 people. Answer, still 4 people. Question, do you recall how you guys entered the gate? Answer, the gate was open for us. Ms. Smith, publishing states 47. Question by Ms. Smith, I'm going to pause it at timestamp 349, looks like 58. Do you recognize that red Jeep Mitsubishi? Answer, I do. Question, is that the vehicle that you left the studio in? Answer, yes. Question, is this the guard gate you testified to at Melly's house? Answer, yes. Question, do you see that screenshot at timestamp 351:31? Answer, Question, is that a yes? Answer, yes. Question, do you see yourself inside that red Mitsubishi vehicle? Answer, yes. Question, and were you located? Answer, and where are you located? Answer, passenger. Question, do you recall going through the gate, going through the procedure of going through the gate? Answer, yes. Question, so you get through the gate, where do you go next? Answer, to the house. Question, all right. And can you tell us, you pull into the house, is there a driveway in the house, in front of the house? Answer, yeah. Question, are there any other cars parked in that driveway when you get to the house? Answer, no. Question, all right. Did you see the gray Jeep that you left the studio with at the house? Answer, no. Question, all right. So what do you do when you get out of the vehicle? Answer, what I remember, I just went upstairs and went to sleep. Question, okay. And you said upstairs. So the house is how many stories? Answer, a couple. Question, okay. So you went upstairs to where specifically to sleep? Answer, to Juvy's room. Question, all right. Was Juvy in his room? Answer, no. Question, do you recall where Melly's room was in the house? Answer, not upstairs. Question, okay, do you recall where it was if it was not upstairs? Answer, I think it was like front first room when you come in the house. Question, was Melly at the house when you got there from what you can recall? Answer, no. Question, did you see Melly at any time in the house? Answer, no. Question, all right, so you go upstairs in Judy's room and what do you do? Answer, crash. Question, crash meaning, answer, go to sleep. Question, okay, at some point do you wake up? Answer, yeah. Question, and why? Answer, phone calls, phone calls, phone calls, phone calls. Question, okay, safe to say your phone was getting a lot of phone calls blowing up? Answer, yeah. Question, and at some point you answered the phone, correct? Answer, yeah. Question, okay, what do you do in response to the phone calls? Answer, I answered it when it kept ringing. And yeah. Question, and so what do you do in response to getting that phone call? Answer, I ended up at the hospital. Question, all right, do you recall which hospital that was? Answer, no, I don't. Question, do you recall what city you were in at this point? Answer, I was in Broward. Question, what city, not the county? Answer, Miramar. Question, do you know if you went to Miramar Hospital? Answer, I don't know what hospital it was. Question, so you get to the hospital, what do you find out when you get to the hospital? Answer, that Anthony and Christopher were deceased. Question, okay, and obviously at that, let me not say obviously, but at that point in time, what do you do or how do you react to that news? Answer, grieving. Question, okay, do you stay at the hospital? Answer, not long. Question, where do you go after the hospital? Answer, I ended up somewhere, somebody's house. Question, all right, do you recall whose house that was? Answer, I don't know whose house it was, but I ended up there. Question, let's start with the city. Do you recall what city that house was in? Answer, Miramar. Question, do you recall if it was in the same or different area than where Melly's house was? Answer, it looked similar. Question, and just to clarify, was it the same or different house than Melly's house? Answer, different. Question, where did you go when you went to that house? Answer, what do you mean? Question, like where in the house did you go? So you go to the house, where do you go? Answer, nowhere. Inside the house, I was in the back. Question, and would your statement refresh your recollection as to whose house you were at? Answer, maybe. Ms. Smith, Your Honor, please permission to approach. I'm sorry, Ms. Smith, Your Honor, permission to approach. I'm going to show defense counsel the same statement, page 4. Question by Ms. Smith. Same procedure, Mr. Glass, if you could just review page 4. Answer, I don't see nothing about a house here. Question, if you could just read the entire page and when you're done, let me know. Have you finished reading that page? Answer, yes. Has your memory been refreshed as to whose house you were at? Answer, I still don't see nothing about a house here. Okay, I'm going to now show you what's in evidence at State 62. Do you recognize individuals in State 62? Answer, yeah, I do. Question, okay, who are those individuals? Answer, Melly and another dude, Frito. Question, you said Melly and another dude, Frito? Yeah. Do you know Frito's name or any other nicknames? Answer, that's all I know, Frito. Question, Frito. Do you recall ever going to Frito's house? Answer, just that time. Question, just that time being what time? Answer, after I left the hospital. Question, and for the record, what is Frito wearing in the photograph? Answer, a shirt, a white shirt. Question, okay, so after the hospital, you went to Frito's house? Answer, to the best of my knowledge. Question, and what were you doing at the house? Answer, still grieving. Question, who took you to the hospital? Answer, the cameraman. Question, do you recall his name? Answer, Drew. Question, and do you recall who took you from the hospital to Frida's house? Answer, same person. Question, and before you left the hospital, or actually, who went to the hospital with you and Drew? Answer, just Drew. Question, who was at the house, Melly's house, before you left for the hospital? Answer, same people that was there when we got there. Question, okay, same people being the 4 people that entered the Mitsubishi? Answer, yes. Question, so you're at Frida's house. You mentioned, and I forgot exactly where you were in the house. Did you say where you were? Answer, Juvy's room. Question, no, not Melly's house, Frida's house. Where were you at Frida's house? Answer, outside. Question, okay, and who was at Frida's house when you first got there? Answer, everybody that was in the house. Question, because I don't know who everybody was or is, can you please specify? Answer, Kobe, Melly, more people I don't know. Question, okay. Was that the first time you saw Melly after you guys left the studio? Answer, yeah. Question, was Melly wearing the same clothes or different clothes than when you saw him at the studio? Answer, nah, he wasn't. Question, nah, he wasn't. You got to specify. Answer, he wasn't wearing the same clothes. Answer, okay. Do you recall what he was wearing? Answer, just had on some shorts. Question, and how long do you stay at Frida Wang's house? Answer, I don't know. Question, okay. Minutes, hours, days? Answer, could be minutes, could be hours. Question, so not days. Answer, not even a day. Question, so when you got to Frida's house, was it light or dark outside? Answer, light. Question, and you previously said yourself and Melly and someone else was at Frida's house. Was Frida there as well? Answer, I think I did see him, I don't remember. Question, okay, what happens while you're there? Like, you're there, you're outside, what happens? Answer, I'm grieving. Question, and you're grieving. Are you grieving alone? Answer, yes. Are you at the house at any point in time? Do more people come to the house or do people leave the house? Answer, if they did come, I don't know. I was in the back there grieving. Question, at any point in time, did Melly leave Frida's house? Answer, it came to a point where I was there by myself. Question, all right, so you were there by yourself. So the people that you previously said were there were no longer there, correct? Answer, correct. Question, and so do you know where they went during that time? Answer, I don't. Question, and we're still talking about October 26th of 2018, correct? Answer, yes. Question, and this would be shortly after the hospital? Answer, yes. Question, at some point does Melly come back to Frida's house? Answer, around that time I'm still grieving, getting a little, I don't know, yeah, I guess. Question, I guess Melly comes back? Answer, yes, I guess they did come back. I don't know, I'm not sure. Question, at some point does Melly leave again a second time? Answer, I don't remember anything from after that. For me grieving, that was the last thing I remember, was me grieving, and I end up in Gifford. Question, so before you end up in Griffin, sick, if I were to show you your statement, would that refresh your recollection as to Melly leaving and coming back a second time? Answer, I suppose so. Ms. Smith, permission to show him statement again? The court, yes, counsel. Question by Ms. Smith. Mr. Glass, I'm going to give you page 5 and page 6. If you could take a look, you can start in the middle and review those pages and look up when you're done. Are you done? Answer, uh-huh. Is that a yes? Answer, yes. Question, Did that refresh your recollection? Answer, somewhat. Question, okay, so tell us what you somewhat remember. Answer, I just did. Question, if you recall, you said you weren't sure, you went to Gifford. And then I asked you if your statement would refresh your recollection. Does your statement refresh your recollection as to whether Melly left again? Answer, I'm not sure. I was grieving. I'm not sure what nobody did. I was grieving. Question, let's see. I pointed out to you someone was, the person that was wearing the jacket that you identified as Melly was carrying something across his side or his back on the video. Do you recall seeing that? Answer, I guess. Question, do you recall what that's referred to? Answer, a satchel. Did you see that question, did you see that satchel again after you left the studio? Answer, no. Question, do you know what was in the satchel? Answer, I don't. Question, okay. Do you recall seeing anyone else with the satchel that night at the studio? Answer, that was 5 years ago. I don't recall. Question, is there anything that can refresh your recollection as to whether or not anybody else was wearing a satchel? Answer, I suppose so. Question, if I were to show you that video again, would that refresh your recollection? Answer, I suppose so. Publishing State 7. Question by Ms. Smith. I'm going to start publishing Start 7, State 7 at 2:19:01. I'm going to pause at 2:19:13. Does the video refresh your recollection as to anyone else that was carrying a satchel? Answer, yes. Question, who, if anyone, was carrying a satchel? Answer, I see Chris with one. Question, and that's Christopher Thomas? Answer, yes. Question, did you ever have any business relationship with the person referred to as Track? Answer, no. Question, okay, do you know who Track is? Answer, not really. Question, not really, or answer, I don't know who he is at all. Question, do you know of him? Answer, yeah. Question, did you see Track on October 26, 2018 at any point? Answer, no. Question, do you recall giving a statement, specifically the statement that you previously provided, that I previously provided you with here today to the detective in this case? Answer, Question, you have to answer out loud. Answer, yes. Question, that was a statement that you gave to Detective Moretti and another detective, I believe from Indian River. Is that correct? Answer, it could be. Question, would showing you that statement refresh your recollection as to anything regarding your interactions with Track on October 26, 2018? Answer, I don't know. I don't know Track. Question, no. My question was, would showing you the statement refresh your recollection as to any time you saw Track on October 26th of 2018? Answer, no. Question, one moment. You said you ended up back in Gifford at some point in time on October 26th of 2018. Answer, yes. Question, and do you recall where Melly was at the time you went to Gifford? Answer, I don't remember. Question, at some point at Frito's house, do you guys all leave, meaning you yourself, everybody that you previously identified that was there? Answer, I don't recall. Question, you don't recall leaving? Answer, I don't recall leaving with anyone. I don't know where I left. I don't know how I left. Question, okay, just to clarify my question, so you mentioned you left. When you left with Gifford, was anyone else at Frito's house? Answer, I don't know. Question, do you recall Melly making any statements in your presence while you were at Frito's house? Answer, I don't recall. Question, would showing you your statement refresh your recollection as to anything Melly told you while you were there? Answer, I don't recall. Question, so you remember them leaving the house at least once, correct? Answer, yeah. Yes. Answer, yes. Question, all right. Now, when they came back, do you recall any conversations that Melly had in your presence that first time after the first time? Answer, I don't recall. Question, would showing you your statement refresh your recollection as to those statements? Answer, no, it wouldn't. Question, all right. Do you have a Facebook page back in October 26th of 2018? Answer, I believe so. Ms. Smith, I'm approaching counsel with what's been marked as state's quadruple I, which was previously shown permission to approach the witness. The court, you may. Question by Ms. Smith. Mr. Glass, do you recognize these two pages that I'm showing to you? Answer, I guess so. Question, and this is a Facebook. Do these statements reflect a Facebook conversation? Answer, they do. Question, is this a fair and accurate representation of the conversation that you had on Facebook? Answer, it is. The clerk states quadruple I will be marked as states 83. Ms. Smith, permission to publish? The court, you may. Question by Ms. Smith. Mr. Glass, can you see that document in front of you? Answer, yes. Question, all right, where it says author, can you read that for the members of the jury? Answer, you want me to read it?
Excuse me one second. Danielle and I keep the message of one of your members needs a restroom break, so we'll take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in his presence. We'll be back in finish reading shortly, as soon as we're done with the restroom break, all right? Thank you. Thank you. Let the record reflect the jury stepped out. Mr. Demons, you need a restroom break?
Yes, sir.
Can we arrange that for Mr. Demons?
Yes, sir.
Thank you. We're in recess. Hopefully forecast, huh? Thank you. Please be seated. Let the record reflect the acquittance of the defendant, the counsel, the assistant state attorney, and the ladies and gentlemen of the jury. When we vote, I think we will vote on the readback of Mr. Glass. Madam Court, could you continue with the readback, please?
Question by Ms. Smith. If you can read that, what does it say next to author? Answer, Fargo. Question, what does it say before Fargo? Answer, Fetty Fargo. Question, do you see where it says Fetty Fargo? Answer, I see it. Question, okay. And who's Fetty Fargo? Answer, it was me. Question, who was that? So was that was that how you identified yourself on Facebook? Answer, kinda, sorta. Question, who were you having these conversations with? Answer, right now it looks like I'm talking to myself, like I was texting. I don't know who I sent it to. Question, do you see where it says participants? Answer, okay, so texting Melly. Question, that was page 1. I'm going to now publish to page 2. I'll publish it in part since it's a little small. Can you see that in front of you? Answer, yes. Question. I'm going to scroll up. What was the purpose of you having this conversation with Melly? Jamell Demons. Answer, I don't know. Just everything was questioned. Question, when you got to Gifford, were you looking for answers? Answer, not just me. Question, were people kind of pressing you for answers? Answer, correct. Question, and did they have any impact whether or not you reached out to Melly? Answer, I don't know what you mean by that. Question, so again, you said that people were looking for answers. So did you reach out to Melly looking for answers? Answer, I did. Question, is that the gist of that conversation on Facebook? Answer, is that just? Question, meaning the gist of the conversation was that the purpose behind the conversation and the general conversation that you had with him? Answer, yes. Question, do you know who Jamie King is? Answer, I don't know who she is. I know of her. Question, do you know her relationship? Answer, his mom. Question, do you know the relationship between Jamie King and Anthony Williams? Answer, I don't. Question, if I were to show you a copy of your statement, would that refresh your recollection? Answer, nope. Question. Sorry, Ms. Smith, and 1 moment to confer. Nothing further at this time. The court, counsel, thank you. Any cross-examination of this witness? Mr. Howard, yes, sir. Good morning, ladies and gentlemen. The jurors, good morning. Cross-examination by Mr. Howard. Question. Good morning, Mr. Glass. Mr. Howard, Your Honor, do you mind if we could move the monitor from in front of the witness's face? The witness, I do, I mind. Mr. Howard, okay. Would you mind, Your Honor? The court, I don't mind. Is there a specific issue that you have, Mr. Glass? The witness, I do. Ms. Smith, Judge, can we approach sidebar? This is direct continued cross-examination by Mr. Howard. Good morning, Mr. Glass. Good morning, sir. Answer. No verbal response. Question. There was no response to this. Answer, no. Question, to your text on the first page. Answer, no. Question, on the second page, the state was discussing that essentially you were inquiring of Mr. Demons, Melly, what had gone on because you were trying to get information. Answer, yeah. Question, and you see a conversation here where you get a response. I want to direct your attention to. Answer, I see it. Question, that statement. It says, I showed them niggas more love than they parents, right? Do you see that? Answer, I do see it, bro. Question, thank you. And the next statement by the next message in sequence is again from Melly. It says, TF, what does that mean? Answer, you tell me. Question, okay, what does that mean? Answer, I don't know. Question, okay, so you were having a conversation and you didn't understand the response? Answer, I don't know what TF means. Question, so you didn't understand that response, correct? Answer, I just said it. Question, okay, then there's another one that says, men, tell them fuck that if they think I did some shit like that. We can go to war. Nigga, you know I would never do nothing like that. Do you see that? Answer, yes, I see it. Question. Okay, so state had mentioned that you got arrested recently and charged criminally, correct? Answer, correct. Question, and on May 30th, not too long ago of this year. Answer, yeah. Question, and one of the charges that was made against you was obstruction of the service of the execution of a search warrant. You're aware of that? Answer, I am now. Question, pardon me? Answer, I am now. Question, so you got charged and you have no idea what you were charged with? Answer, correct. And you are now on pretrial release? Answer, I bonded out, sir. Question, okay. And while you're out on bond, you are of the opinion that if you don't come here Answer, I'll be in jail. That's the only reason. The court, excuse me, what happens is when they make objections, you wait before you answer. Objection overruled. The witness, got you. Hold on just 1 second. I'm going to reread that portion. Okay, and while you are out on bond, you are of the opinion that if you don't come here, I'll be in jail. Ms. Smith, objection, Your Honor, relevance. The witness, that's the only reason. The court, excuse me. What happens is when they make objections, just wait before you answer. Objection noted, it's overruled, proceed. The witness, got you. By Mr. Howard, question. You're of the impression if you don't come here and sit in the chair and testify, you're going to go to jail. Answer, correct. Question. Okay, there are several instances in which Ms. Smith, the prosecutor, that questioned you, showed you a statement that you previously gave. Remember that? Answer, yes. And you told us you remember seeing me in the deposition not too long ago. Answer, I said what? Question, you remember seeing me last week on Friday? Answer, yeah, I remember. Question, and you recall at the time that your statement to the detective was a few days after the incident? Answer, you say, do I recall? Question, that's what your recollection was at the time? Answer, yes. Question, a couple of days after? Answer, a couple days after. Question, and now after seeing the statement, you realize that it was 4 months later, right? Answer, you say what? You said what? Question, the statement you gave to police. Answer, you're telling me it was 4 months, or asking me. Question, pardon me? Answer, are you telling me or asking me? Question, I'm asking you. Answer, that don't make sense. If you asking me, I told you it was there. It was 3 to 4 days after they died. Why are you asking me if it was 4 months if I just told you? Question, okay. So in the statement that you gave to police back then, you claimed that you had gone into the red vehicle in the rear seat, right? Answer, that was 5 years ago. To the best of my knowledge, that's what I said. Question, you're saying the statement was a few days after, right? Answer, what did, question, the statement that you gave to the police was a few days after the incident? Answer, yes. Question, and you said then that you had gone into the rear of the red vehicle? Answer, to the best of my knowledge, yes. Question, and then you watched this trial unfold on TV over the last couple of weeks, right? Answer, no. Question, you didn't watch any of this trial? Answer, I watched it, but I didn't watch it unfold or whatever you're trying to say. Question, okay. You watched this on TV, this trial? Answer, on the phone. Question, and you saw a video of yourself get into the red vehicle, right? Answer, correct. Question, and you learned that the statement that you gave a few days ago, a few days after the incident was gone. Let me reread that question. And you learned that the statement that you gave a few days after the incident was wrong. Answer, because I said I was in the back and I was in the front? Question, yes, exactly that. Answer, that piece? Question, yes, that piece. Answer, okay, yeah. Question, you forgot where you sat in the vehicle a few days after? You can answer. Answer. Answer what? Question. That question. Is that correct, sir? Answer. Did I forget? Question. Did you forget? Answer. I could have made a mistake and said I was in the back and remembered that I was in the front. Question. So when you told the law enforcement officers that you had gone into the back of the vehicle a few days after the incident? Answer. That's what I thought to the best of my knowledge. Question. That's what you thought? Okay. And when you got to Melly's house that morning, you had a key? Answer. Did you have a key? Question. No, I didn't. Did you? Answer. No, I didn't. Question. Who had a key? Answer. I don't know. Question. Do you know of anybody having a key to Melly's house? Answer, I don't know. Question, okay, but you did gain entrance to the house that morning after you left the studio. Answer, yeah. Question, and then you said you just went and crashed and went to sleep in Juvy's room, right? Answer, factual. Question, and you were awakened by your friend Drew? Answer, I did not say that. Question, were you awakened by your friend Drew? Answer, I said I was awakened by phone calls. Question, did you ever make a statement differently where you claimed that you were awakened by Drew? Do you understand the question, sir? Answer, I don't even remember getting asked a question. The court, all right, restate your question. Question, did you ever make a statement to the police? Answer, I don't recall. Question, okay, do you recall now being asked this question and giving this answer? Question by the detective. Then, and so when you first saw Drew, when did you see him? Where did you see him at? Your house or Frida's house? Answer, at the house in Miramar, at Melly's house, okay? He woke me up. It was like, come to the hospital. You said that? Answer, I don't recall. Question, don't recall? All right. When we spoke to you last week, you said you were awakened by phone calls from Christopher Thomas's mom, right? Answer, plenty of phone calls, different people. Question, pardon me? Answer, different people. Question, different people. And the one that you answered was Ricky. So you were awakened by a phone call from Ricky. Answer, to the best of my knowledge. Question, so as you recall it today, Ricky is the one that woke you up with phone calls and not Drew that woke you up in person. Answer, correct. Question, okay, so you smoke a lot of marijuana, right? Answer, possibly. Question, you smoke it anytime you get a chance, I think is how you phrased it. Answer, it's your answer, yeah. Question, that was your answer. Answer, I smoke when I smoke. Question, you smoke when you smoke? Answer, yeah. Question, and when's that? Answer, when I smoke. Question, and when would that be? Answer, when I smoke. Question, how many times a day? Answer, twice, 3 times maybe. Question, and on the night in question, before you got to the studio, on the day in question, you had smoked at least 2 joints, right? Answer, that's your guess. Question, that's what you said, right? Answer, I don't recall. Question, okay. And when you got to the studio, you were smoking, correct? Answer, possibly. Question, were you or weren't you? Answer, that was 5 years ago. Question, you forgot? Answer, I don't recall. Question, and you were drinking Hennessy, I believe, or do you not recall that either? Answer, it's possible. Question, possible, but you don't recall. Answer, I don't. Question, okay, so you don't recall much from that night then, do you? Right? Fair? Answer, right. Question, and when you got in the red vehicle and left, you went to sleep in the vehicle when you left the studio, right? Answer, yeah. Question, and you didn't wake up until you got to the guard gate? Answer, I woke up when we came to a stop. Question, you did not wake up until you got to the guard gate. Am I right or wrong? Answer, I woke up when we came to a stop. It was at the guard gate, yes. Question, have you ever seen track with a gun? Answer, it's possible. Yes, maybe so. Question, okay, so you don't know of any friction between Melly and Anthony Davis at any time. Anthony Williams at any time. Answer, not that I know of. Question, and you don't know of any friction between Melly and Christopher Thomas at any time. Answer, not that I know of. Question, you didn't see any friction at the studio that night of any kind, did you? Answer, I didn't. Question, you did? Answer, I didn't. Question, with respect to your daily marijuana regimen, did you smoke Did you smoke before you came here today? Answer, I did not. Okay, I have nothing further, Judge, thank you. The witness, I should have. The court, counsel, is there any redirect, Ms. Smith? Briefly, your judge. Briefly, Your Honor. Redirect examination by Ms. Smith. Question, Mr. Glass, did you live in Broward County back in October of 2018? Answer, I did not live here. Question, okay, when did you come in relation to this incident in Broward County? Answer, I was picked up probably, I don't know, I was picked up on the weekend or something like that. Question, so how would you, I guess, date how long you were here prior to the incident, time frame? Answer, 3 days, 2 days. Question, okay, so you were not a full-time resident of Melly's residence? Answer, I was not. Ms. Smith, nothing further. This witness excused? Yes, Your Honor. You may step down.
That concludes the readback of the witness Cortlen Glass's testimony, so you may now retire and continue with your deliberations. Thank you, ladies and gentlemen. Thank you. Let the record reflect the jury stepped out. Counsel remain on the defendant. Counsel, I have another question that the jury posed when they came in for readback. And the question reads, what is the conversion to 1 meter equals how many feet?
Rely upon the testimony. You rely upon the testimony.
Everybody agrees?
Yes, sir.
Can I do that just in writing here? Is that all right with everybody?
That's fine. I'm sorry. Your Honor, I think you should say you must rely upon the testimony.
That's what I started to write.
I'm sorry.
No, you're right.
I'm sorry. What did you just say? I'm right. Can I get that typed up, please?
More than once I'll say it. You must rely upon the testimony. Anything else you want to say? Stay, is that all right?
That's fine, right?
There are foods here, so we're going to utilize this time for lunch.
You hear that?
Lunch?
Lunch.
When should we be back?
You tell me, I mean, where are you going? You buying?
Yes.
The 30-minute window thing is out the window.
No, I mean, 30 minutes, that's fine. Just be available.
Yes, sir. You have our numbers.
All right, is that good with you, Madam State?
Yes, sir.
All right, so we need to avoid it. All right, thank you.
Thank you, sir.
We're in recess. Lunch, I received one message from the jury signed by the foreperson, and it basically is the box is checked, requested new evidence, hyphen, rescind previous request, goes on stage, jurors who requested to, wanted to hear the testimony of Michael Kelly, have rescinded their request.
We apologize for any inconvenience, so we don't need to read back to Mr. Kelly what we're telling us. Second thing is, when Dale was in there, I guess, trying to get them lunch or something like that, bring them a lunch, he received from not the foreperson, but a short note. It was folded up.
That's good.
And it was folded up, and it was passed to him, and it says, "Are we allowed to have Apple Watches? Someone has one." It's not signed or anything, but that was the message that was passed to me. And that's why when we got the message, I try to get everybody to come back to just talk about it.
Was that another jury? Open sure.
Yes, sir. We're going to wait for 1 second, so I want Gary in here.
Okay.
And he just wanted to respond to the pleasure.
On the mic over here. Cause what? I can't even reach it over there.
Let the record once again reflect the presence of the defendant, his counsel, the assistant state attorneys. So what I was sharing with you regarding the message that Gary advised me was that yesterday when we started, sent the jury to deliberations, Gary asked for all their electronic devices or phones, including smartwatches and Apple Watches. And in fact, one of the jurors has an Apple Watch and presented it to Gary, which he has it secured with all the other electronic devices. Is that correct, Gary?
Yes, sir.
And secondly, he's also indicated that when he viewed various jurors, he was unable or did not observe anybody wearing a smartwatch. Is that correct?
Correct.
So I don't know how you want me to handle this, and I guess that's one of the things you could talk over for a second amongst yourselves. And I also have a message here from the jury, another message, and it says, "What if we can't come to a decision? Question mark. Everyone is stuck on which side they've chosen." Signed by the foreperson. So,
I think we're prepared to the extent that the court is, I think we're prepared to offer our responses.
that's fine. If you're ready, Madam, are you ready?
Yes, sir.
All right, go ahead.
I know the court's not going to want to hear this, but with respect to the first of the notes,
Excuse me, when we talk about the notes, we're talking about the one.
okay, the first would be the Apple Watch, okay.
The individual juror.
Individual juror Apple. As far as that is concerned, my understanding of how Apple Watch works, at least how mine works, is that there has to be some proximity to a phone for it to provide access to the internet. I don't know if I'm wrong.
There are versions that have selling and cellular capabilities outside of the phone.
All right, so I guess we need to inquire with respect to who that might be that has it. And it would just be, we would suggest that we identify who it is, we just retrieve it and keep it moving.
So I think on that, but remember, pass the note to your deputy, bring that potential particular juror out, and ask who has it, so we actually know.
No, I wouldn't want to isolate them. I'd want to bring up the whole panel and have the court inquire as to whether or not anybody has any remaining electronic devices.
But as part of the court's instructions in 3.13 indicate that if anyone becomes aware of a violation of these rules, which includes not having an electronic device, they must inform the court. I think for record purposes, we just identify the person who has the Apple Watch and needs to be removed from the room. We don't know whether there have been any other violations, perhaps someone looking up something online, unless we inquire further.
Thank you. We all done, Andrew?
Well, two things, Your Honor. One, the person in passing up that note did abide by the court's instruction that Ms. Smith just referred to, but it doesn't say necessarily bring them out and single them out and expose them as a snitch. and I think we're jumping the gun by suggesting that if we find that somebody had an Apple Watch, they need to be removed from the room. The Apple Watch needs to be removed from the room. Is that what you're saying? Okay, so we concur in that respect. As far as this one.
This is my thought, respectfully. I just bring the jury in as a group, just let them know I have a message. This is, are we allowed to have Apple Watch if someone has one? I don't know if this, when they're talking about this. One of the jurors does have an Apple Watch, but it was taken away, or not taken away, but they presented it to Gary when he asked for it the other day before the jury went into deliberations. He goes in and just retrieves all the phones and electronic devices, and they present it to him. So maybe that. And I'll ask again, I'll ask somebody else to watch on them now or anything like that, a smart watch. And you'll see what the response is. If they say nobody responds to it, no smart watch, then we'll take the next step and we'll see where we go from there. But I'm going to ask the jury as a whole if anybody has a watch.
Your Honor, with respect to that, the only suggestion that I would make would be for the court to inquire if anybody does have an Apple Watch. When they go back to the room, please give it to Gary as opposed to them feeling castigated in front of the public.
I still need to know, though, if somebody has a watch and they give it to Gary,
Who it is?
I need to know, make sure they haven't used it. Because he specifically, I instructed them they can't have it back. I don't know that I ever talked about smart watches or Apple Watches per se, but I know in the standard instruction which I read to them, I'm told they can't have electronic devices, phones, cell phones, any electronic device have to be left here in the courtroom. Gary goes in and does it again, and when they go in, make sure he collects everything, so, and he has it stored. So let me just take it one step at a time, and we'll see what they say, and then if we need to inquire further, we'll talk about it.
Okay.
All right? So just ask the jury to come in for a second.
Yes, sir.
Oh, wait a second. I'm sorry. Did I mention this to you?
The third?
I got another one. Another question.
Your Honor, at that point, I think it's appropriate to read the Allen charge based on that specific comment. I can print copies for the court and counsel.
Well, it says here, what if we can't come to a decision? Doesn't mean they're at an impasse now. Everyone is stuck on which side they've chosen. So if they say they can't reach a decision, that's one thing. But this doesn't really say they can't reach a decision. It says, what if we can't come to a decision?
I think they're saying they have not. And what if meaning what is the procedure that we follow now that we are in that place, as opposed to what if that eventually happens. So we interpret it a little bit differently, Your Honor. As to what we should do about it, I'd like to confer with co-counsel. As to the other note, this is the part that I know the court's not going to like too much. We have made taken a position that the statements that were requested at the same time and should be read back at the same time. Now we've received a situation, or now we've come to a situation where testimony that by a state witness was put on, and I know we're reading tea leaves, but because we're in that position, we need to account for every eventuality and possible scenario. I would hate for it to be that the jury that has now rescinded its request for the other testimony has done so because they have now been either browbeaten or convinced of a certain position because they lacked the ammo in terms of Kevin's testimony to retort. So I know that forcing the jury now to read a transcript which they have said they don't need might not be optimal. And so in order to preserve our objection, I would not propose that, but I would move forward on that basis.
Thank you.
Thank you, sir.
So there's a motion for mistrial, the state which we heard.
I want to make sure I understand. The motion for mistrial is based on the jurors rescinding their request?
That's the way I understand it.
Well, it's based on the fact that we did not provide them the two statements at the same time, and now a request has been made to rescind, the request to see one of them has been rescinded. So it's not the fact that they have rescinded, it's the fact that the court denied our motion to read them at the same time, and now that has resulted in them rescinding the request for one. So that's the basis, to be complete.
My question, stay with the response.
No, Your Honor, not manifest necessity.
Thank you. Motion denied. All right, so what I'm going to do then is, and what do you want to do about the Allen charge? Is the state agreeing, the minor state is defending?
We've asked them to print it out so we can look at the Allen charge, if they could, and then we need a few moments to discuss it with the court's permission. I'm sorry.
I'll print it now, if that's okay, just so it's a little more.
That's all fine, well and good. That's fine. Go ahead. We'll be in recess.
Thank you.
We are all, second paragraph, we are all aware that it is legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. We are fine with that as well. The third paragraph, I don't think is necessary. I don't think it's implicated here. And it says there is nothing to disagree about on the law. The law is as I told you. If you have a disagreement about the law, I should clear them up for you now. That should be my problem, not yours. I don't think anything about any question or any statement the jury has made so far implies that they're unclear about the law and they have a set of jury instructions there. So we would object to that paragraph. The fourth paragraph reads, if you disagree over what you believe the evidence showed, then only you can resolve the conflict if it is to be resolved. We would prefer that it says only you can resolve the conflict if in fact it can be resolved. The words, if it is to be resolved, that phrase has a certain sense of inevitability, which seems like it's urging them to resolve it. And so we would ask that to be changed to if in fact it can be resolved. The next paragraph we would like eliminated completely. And it says, I have only one request of you by law. I cannot demand this of you, but I want you to go back in the jury room, then taking turns, tell each of the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's view until each of you has had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your service. I don't think we should be telling the jury how to go about the function of deliberation and suggesting to them that they each get up in turn and give a dissertation as to what they think the weaknesses of their own position are. I think is an unconstitutional intrusion on the function of a jury in its deliberation, and we would object to that. The final line says you may now retire to continue with your deliberations, and we're okay with that. Excuse me one second.
Your Honor, I have a vague recollection of any modifications to that being a problem. I'm trying to read, I believe it's out of this circuit, 2015 Almeida v. State. I haven't had a chance to read it in full, but I have.
But you're objecting to the change?
Yes, I'm trying to read through, because I know it's
which is a Florida Supreme Court case 748 Southern 2nd 970 pinpoint or citation point 978, and it says in part a somewhat similar situation arose in Young versus State, and it cites Young versus State where the court held the judge's deviation from the standard jury instruction by one sentence was error. I know that there's a lot of case law on just disapproving a modification of the Allen charge. The state's position would be that it should be read in total to the jury as to not comment on what portions or not. I think to isolate certain paragraphs would be truly suggestive and have a negative impact on whatever issue will happen.
Your Honor, I'd like to know if that case that you read concerns jury instructions at large or an Allen charge?
Allen charge.
It is an Allen charge.
Who asked for the modification, the state or the defense?
Probably the defense, but yes, Thomas, the defendant, asked for the Allen charge for the standard jury instruction after the jury deliberated. The standard Allen charge is not given.
And it says that a modification can be or is error.
It says in Young versus State, which is cited in the Thomas case, that the deviation from the standard instruction by one sentence was error.
Okay. So it's all contextual, so we want a chance to take a peek.
Sure.
I guess it's own as well.
Well, this is my question, though. The way I read this jury inquiry form, it states, what if we can't come to a decision, question mark? Everyone is stuck on which side they've chosen. That's the question. So, are you telling me, both sides telling me that they interpret that the jury is deadlocked? It doesn't say that to me. It says, what if we can? It doesn't say we can't come to a decision. It doesn't say they're deadlocked.
The second part does. That we're stuck in our respective camps. So that's the declaration of deadlock.
They agree, it's an indication there of deadlock.
So if both sides agree, this is interpreted as a deadlock and they're stuck. Is that what you're telling me? Both sides agree with that?
Yes, Your Honor.
Yes, sir.
Then I'm going to read the Allen charge. Right? I mean, I'm not modifying it. That's a standard that's been around for 40, 50 years. I'm not modifying it. The state objects to any modification. It's not agreed. I'm not going to modify it.
Can we take a chance and look at the case law?
Sure, go ahead.
See whether or not there's some distinguishing language.
I'm going to print comments.
Thank you. Even though Howard didn't say that.
I apologize for this. That's no problem.
We're happy to look at whatever case you want.
1999 for Thomas versus State.
I don't have anything.
Basically, this is continuing for the last paragraph we read, which I wrote, I only want to help you through, after you've done that, consider the number 2 verdict, and return to the courtroom, and I will discharge you for the as opposed to, I will declare this case mistried, and will discharge you with sincere appreciation for your services. That was the change that was made. I'm trying to find out as to who requested them. It was Thomas.
In other words, the change wasn't as to the substantive instructions to the jury. It was as to whether or not the effect of their further deliberations. So in other words, it's giving them an Allen charge and then telling them, and even if you were deadlocked, I'm going to send you home, which is completely different from the substance of the charge itself.
And I think, at least the way Thomas interprets Young, it's saying that the judge made that error, and that was the judge's suggestion to modify the, and defense objected to the modification. So that's, yeah.
We're asking.
So I don't think I need to speak further to the distinction there, which is the defense saying if the jury is saying they're deadlocked and we've read them Allen charge and Allen charge says that if you still can't, case over, sending them back in for another day would be an element of compulsion that would be unconstitutional. So we could see where that, but we like to see if we can distinguish in any other cases. And Allison wanted me to make this point, which is pertinent, which is that in that case, the defense was the one that objected. Here, the defense is requesting it. So we would have waived our opportunity to object should the court grant our request. Or that explanation was that Thomas? Okay.
Hold on, I think it's that Miramar.
No, I see it in Thomas. I see it in Young. That's in Thomas as well. It's the same issue.
Yeah.
Okay. So yes, Your Honor, the Thomas case that the state cited was Thomas v. State, 748 Southern 2nd, 970. It's a 1999 case, Supreme Court of Florida. And that also cites to a state, Young v. State, which is 711 Southern 2nd, 1379, a 1998 case out of the 2nd District Court of Appeals. And the state has represented the issue that Thomas addressed. I'd like to just read some language here from Young that indicates that Young was treating the same issue. In the very second paragraph of the opinion, it says the jury began its deliberations in this case near 5 p.m. on the second day of trial. At or near 9 p.m., it informed the court, quote, as a group, we cannot agree on a verdict, end quote. The trial judge made the decision to give the jury an Allen charge. It is proper for a trial judge in a criminal case to give the standard Allen charge where it appears the jury is deadlocked. The trial judge also decided, however, that he did not want in this trial that night and would bring the jury back the next morning. So it's the same issue, which is we're going to give you an Allen charge, but it's not going to be effective because if you still can't reach a verdict, we're going to bring you back tomorrow. So it's the same issue in Thomas, and we think that's different from the notion that a Allen charge cannot be modified at all to suit the circumstances of a particular case. Here, I don't think there is any need to tell them about the law because nothing they've said implies the law. And we also think that it invades the province of the jury to tell them that they should each get up one at a time and explain the weaknesses of their position. That is not only counterintuitive to an advocate, and they're advocates for their respective positions. It's counterintuitive to an advocate, and I think it's an unconstitutional invasion of the province of the jury. They should conduct their deliberations and discharge their constitutional function as fact finders without our interference. So we would object.
State, anything else? So let me ask you this, how do you want me to, my thought is I'm going to handle this question first about who's got a cell phone, if anyone. I'll ask them that as a group. and then I'll read the second inquiry form as what if we can't come to a decision, and then I'll read the jury deadline. I understand the defense's objection to it. The instruction's been around for over 40 years. Stood the test of time.
Thank you, Your Honor.
Respectfully, I'm not going to modify it.
Thank you, Your Honor. I'd just like to read this before the court. I understand the court has made its decision, but Mr. Adelstein brought something to my attention out of the Thomas case, which is a Supreme Court case. And it says, as noted, every Allen charge issue must be decided upon the particular facts and circumstances surrounding an individual case. So that goes to the issue of individuality and whether or not it should be tailored to the circumstances of a particular case. And we're taking a position that mirrors what the Supreme Court has declared, that modification of Allen charges is not foreign. As a matter of fact, the Supreme Court has directed that it should be tailored to the circumstances surrounding an individual case, so that we maintain our objection.
Thank you.
Thank you, sir.
So, want to bring the jury in?
Yes, sir.
Jurors entering. Thank you, counsel. You can see that the record once again reflects the presence of the defendant, the defendants, and the counsel, the assistant state attorney, and the ladies and gentlemen jury. Ladies and gentlemen, two things. First, I received a note, or my bailiff did. It's not signed by the foreperson, but it's a note that was handed to him. It says, are we allowed to have Apple Watches? Someone has one from one of the members of the jury. As I tried to explain to you earlier, all the electronic devices are basically, we're not allowed to have those in the jury room, so we asked our bailiff, Gary, to try to collect them. Does anyone have an Apple Watch? Yes or no? In their possession? I asked the question. Does anyone have one? No? I see everybody raising their hands, or several raising their hands showing they don't. All right, there's no Apple Watches. Thank you. The second thing I want to do is, based upon, I received this juror inquiry form that is signed by the foreperson that reads as follows. State of Florida versus Jamell Demons, case number 19-001872, CF10A. Check the box, ask the following question. What if we can't come to a decision? Everyone is stuck on which side they've chosen, signed by the foreperson. All right? So what I'd like to tell you, or read to you, is an instruction that's called Jury Deadlock 4.1. And it reads as follows. I know that all of you have worked hard to try to find a verdict in this case. It apparently has been impossible for you so far. Sometimes an early vote before discussion can make it hard to reach an agreement about the case later. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it's legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on the facts of the case. Excuse me. There are two things that a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. There is nothing to disagree about on the law. The law is as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem, not yours. If you disagree over what you believe the evidence showed, then only you can resolve that conflict, if it is to be resolved. I have only one request of you. By law, I cannot demand this of you, but I want you to go back to the jury room, then taking turns, tell each of the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's views until each of you have had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your services. Ladies and gentlemen, you may now retire and continue with your deliberations. Thank you, Mr. Murray. Before the jury step down, Counsel may roll the defendant. We'll be in recess.
Thank you, sir.
Sorry, Ruby, I apologize.
Who would open the door?
I normally open it for Ruby.
Make sure we're all in the same place. Everybody agree?
Yes, sir.
Yes? We're all good?
Yes, sir.
All right. So can I bring the jury back in now then?
Yes, Joe.
Yes?
Yes, sir.
Yeah, you think I forget whether we did during trial, do you need a light
Yes.
gift or not? Yes? All right. So you want to bring the jury back in? Yes, bring it back up.
You cold?
Jurors entering. Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, his counsel, his assistant attorney, ladies and gentlemen, the jury. Ladies and gentlemen, I have a request of you evidence here. It says you requested the traffic video from 595 to see what time the Jeep and Mitsubishi passed the express lane cameras. We attempted to pull up the footage on a laptop, but it would not play. I've asked counsel to secure that portion of the evidence for you, and it will be replayed for you now. You ready, counsel?
334:53.
Defense, yes, does that complete the publication?
I believe so.
Thank you.
Thank you.
Thank you, ladies and gentlemen. You can go back to the jury room. Continue with your deliberation. Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant. We're in recess.